And I would like to introduce our presiding arbitrator, Cecilia Yu, who will commence the session and to introduce her co-arbitrators and invite the teams to introduce themselves briefly.
I believe we're missing Madam President because she can't see her. Ah, here she is.
Cecilia. So let me introduce Cecilia Xu, who is our presiding arbitrator. She'll introduce the co-arbitrators and invite the teams to introduce themselves. Cecilia?
Hello, I do apologize. Somehow I got a technical issue and I was somehow my line got broken out.
No worries, Cecilia.
Thank you.
It's part of the game.
I do apologize.
No worries. So Cecilia, thank you very much for presiding today. Could you please invite your co-arbitrators to introduce themselves and then the teams to introduce themselves and their order of argument and deal with any procedural matters?
Yes, of course. I shall be honored to do that. Thank you, Christian. Dear teams, dear colleagues, I have two arbitrators, co-arbitrators judging this session with me together. I am the presiding arbitrator. My co-arbitrator, Pierre from Italy, Netherlands, and also the other co-arbitrator, Nicolas from Indonesia. Good evening, good afternoon, good morning, everyone. My name is Cecilia Xu. I am based in London. I am a commercial barrister and arbitrator. So I hand over to my co-arbitrators, Pierre and Nicolas, for them to give a brief introduction of their own practice. And then we will start this session. Thank you very much.
Thank you, Madam President. So my name is Pier Giuseppe Pucedu. I'm an Italian lawyer, actually based in the Netherlands, and I'm also a university researcher. I will co-arbitrate in this round today, and I will also keep the time. So please, when the teams introduce themselves, you speak clearly how much time you are allocating for your presentation and rebuttal. And I will be writing in the chat box how much time is left, starting from 10 minutes left, 5 minutes left, 2 minutes left, and then time is over. And I will do the same also in the case you ask for extra time. Please be reminded that if you need extra time, there is 1 minute extra time. You do ask it, otherwise you might get in trouble because you run over time. So this is just, you know, repetita juvant, we would say in Latin. And this is it, and I hand over to my other colleague. Thank you.
Thank you so much, Pier Giuseppe. Hello, everyone. My name is Nicola Luzada. I am Colombian attorney, but I'm currently based in Indonesia. I'll be here for a few months, but then I've been involved in arbitration for the last 15 years, but in moot courts for the last almost 20 years. So I think this is something that's I'm really passionate about. I think you're having a great opportunity. Just enjoy the session that's coming. It's going to be a lot of fun.
Thank you, Nicolas. Thank you, Pierre. So everybody, all the advocates, counsels, we truly hope that you enjoy this session. Like I said, Pierre will keep time and we will ask you questions from time to time. Please do not worry about you complete or not of your written submission because we have them in front of us. We want you to present your case, the laws, the facts, the issues to the tribunal so that you can present your case clearly and then we will determine on the issues. All right. So now let's start. And I hand over to my co-arbitrator, Pierre, so that he will manage the time.
Thank you, Madam President. And so the team can introduce themselves and tell us for how much time they are going to speak. Thank you.
Good evening to the members of the tribunal. My name is Anjali Busar. I'm respondent's first counsel. I'll be reserving 19 minutes for my pleading and 1 minute for rebuttal. And same goes for my co-counsel, who is Counsel Submissions. He'll be reserving 19 minutes for the pleadings again and 1 minute for sir rebuttal. Thank you.
Perfect. Thank you.
Claimant team.
Yes. David.
Am I audible?
Yes, you are.
Yes, all right. Greetings, members of the Tribunal from India. We will be taking 19 minutes for our speech. I will be the first speaker from the claimants addressing procedural issues, and we both will be reserving 1 minute for rebuttal and sir rebuttal.
Perfect.
Thank you.
Thank you.
Let's start. The time is 11:59. Obviously, I can't see seconds. Let's just treat it as 12 o'clock dead on, shall we? Pierre, if you agree with me. And yeah, so I think we should start now.
Yes, please, team, proceed.
May I proceed?
Yes, please.
Thank you, members of the tribunal. Good evening to the members of the tribunal. My name is Anjali Busar, and I, along with my co-counsel, Mr. Counsel Submissions, will be representing the respondents, the Federal Republic of Myanmar, in the present arbitral proceeding. I will be addressing the tribunal on the jurisdictional as well as the admissibility issue, and afterwards, my co-counsel will address the tribunal on merits. Learned arbitrators, we went the whole 9 yards, or we could say that we have been a victim of the suppressive plans of the government of Bunru. They have tried to exploit our resources for its own benefit under the garb of Bema holding. While their ill-planned actions have already done serious harm to Kelly Airways, the utter disregard they have shown to this dispute resolution mechanism is nothing but an attempt to escape the consequences of their wrongdoings. And the present dispute before this tribunal is nothing but again a further attempt to deny us justice. The entire
Counsel, but the dispute resolution mechanism in the state would apply to all the enterprises and litigants, won't it? Instead of just applying to you, to the respondent.
Madam Arbitrator, this dispute resolution mechanism that I'm referring to is with respect to the state-to-state arbitration. And here this present dispute is a state-to-state arbitration, and that is why we cannot include that within the mechanism which we have before us, which is the ICSID additional facility rules. If that clarifies your concern, Madam.
My concern is, if you say that the dispute resolution mechanism is prejudicial against your client, then I'm afraid I'm not persuaded by that, because surely the country's, the state, the nation's dispute resolution mechanism is applicable, universal, whoever is in that jurisdiction.
Ma'am, here the primary contention of the claimant side is that they are an investor and they fall within the ambit of this convention as well as the applicable treaty, which is SEPTA. However, we will prove from my or later arguments that BEMA's conduct are clearly attributable to state, which transforms this dispute into a state-to-state arbitration, and that cannot be included within the ambit of ICSID AFR, which is the additional facility rule.
You are saying that by transforming the dispute into a state dispute, in that sense, the dispute resolution mechanism is prejudicial against your client.
Yes, Madam Arbitrator.
Understand. Yeah, please proceed. Thank you.
The entire conflict rests upon the issue of whether BEMA, while being a state-owned enterprise, could be granted a standing under SEPTA as well as the institutional rules. And to substantiate on this, I will be focusing on two major submissions. With respect to the first one, members of the tribunal, the conjunctive reading of additional facility rules with respect to SEPTA itself clearly leads us to the point that it is crucial for the mandating parties to meet the procedural requirements, which is that a dispute has to be between an investor and a state to be included within the ambit of this convention. Even from the outset of the convention's negotiations, there was a general agreement that state versus state or private versus private disputes were to be excluded from the jurisdiction of the center. And an additional policy goal supporting such exclusion was the depoliticization of investment disputes. Even the drafters of the convention were very keen on emphasizing that ICSID was not meant to be used for the settlement of interstate disputes because such could be adjudicated through other methods under international law. Here, in the present dispute, WEMA has been a... Do I sense a concern, members of the tribunal?
No.
Here, in this dispute, WEMA has been a state-owned enterprise from its very inception. And that is why the reason for that is that the Bundu always maintained a sizable stake in the company. And this transforms this dispute into a state-to-state arbitration. And we humbly submit before this tribunal that they lack jurisdiction, as this dispute is again a state-to-state arbitration. Coming to the second prong of my submission, members of the tribunal, here, for the purpose of this convention, Aaron Brochus has laid down a test, wherein he has stated that a mixed economy company or a government-owned corporation cannot be disqualified or should not be disqualified as a national unless first, it is discharging an essentially governmental function, and second, it is acting as an agent of the state. It is pertinent for the tribunal to note here that Brochus factors are strikingly similar to attribution articles engraved in ILC articles on state responsibility, and therefore I'll be applying these articles mutatis mutandis. Members of the tribunal, in order to identify whether a particular entity is a governmental entity engaged in carrying out governmental function, various authors such as James Crawford and various ICSID tribunals have laid down two-pronged tests, which is a structural analysis and a functional analysis. Mr. Arbitrator, I sense a concern.
Sorry, I was muted. Agent, one brief question. Do you believe that the doctrine by the authors that you mentioned will be binding for this tribunal?
Mr. Arbitrator, the ICSID tribunals, various case laws, as well as the most important commentary on ILC articles on state responsibility presents this test before us, and therefore it can be binding on the tribunal. And I will prove through my further arguments that how
but then you're saying that jurisprudence and there's a precedent under international investment arbitration. Is that your claim, Agent?
Members of the tribunal, as there exists a dearth of jurisprudence in ICSID convention, coupled with the fact that Brochus' test is strikingly similar to the attribution articles here, and therefore we are...
Agent, I believe this is a yes or no question.
Pardon me, Mr. Arbitrator, but could you please repeat your question?
Yes, Counsel. I would like to know whether you consider that under international investment arbitration there is a precedent.
Members of the tribunal, there are various cases on which I will rely on. So yes, these proceedings. So yes, the law laid down in the international investment arbitration, which is the ICSID additional facility rules, that becomes binding on the tribunal.
Are you familiar with the Roma case with Uzbekistan?
Yes.
So do you know what the tribunal said in that regard?
Learned Arbitrator, that present case, that Rumeli versus Uzbekistan case, talks about the state enterprises. Here, the present situation...
No. I'm referring to the jurisprudence nature of international investment arbitration.
Pardon me, Mr. Arbitrator, could you please elaborate a little more on your question?
Does the tribunal indicate anything as to the question that I'm asking, whether international investment arbitration operates under precedent system?
Mr. Arbitrator, here I'm referring to these commentaries and ICSID tribunals to further substantiate my point that this present situation before us as how WEMA's conduct is attributable to state which translates.
Counsel, I'm afraid you're not answering my question. Just you cannot actually say that you don't know, but you don't avoid me, please.
Yeah, I have the same difficulty, Counsel. I think this is a straightforward question, yes or no question, because I am struggling in seeing whether any authorities would bind this tribunal so that we are bound by any case law you would cite or by any rules, by any international laws. Are we bound by those authorities you would cite?
Madam Arbitrator, yes, with respect to the precedent, the tribunal can use those authorities in our favor. However, then later they can pass any order as it may deem fit.
So in essence, we are not bound by the authorities you present.
Madam Arbitrator, these authorities are passed by the ICSID tribunals themselves. Therefore, they lay down a precedent before us. And therefore, it presents a detailed analysis with respect to our present situation also, that those precedents can be utilized in our case too, because some of the cases are strikingly similar to ours.
Yeah, Counsel, the question again, like say, is a very straight question answer. We are looking for yes or no. Are we bound by ICSID authorities or not?
Yes, Madam Arbitrator, if that is your concern, yes.
Okay.
Right, please proceed.
If I may proceed. Thank you, Madam Arbitrator.
Thank you.
As I was continuing with my line of argumentation with respect to Broch's test, I reiterate the point that Broch's factors are strikingly similar to ILC articles, and therefore I'll be applying the structural and functional test. And I will present a detailed analysis on both the tests separately and will explain as to how WEMA, in terms of both structural and functional analysis, was a governmental entity engaged in carrying out governmental functions. Coming to the structural analysis, members of the tribunal, here there exists no official definition as to what constitutes a state-owned enterprise. Therefore, relying on the material present before us, which is the definition given by OECD, it says that in any enterprise in which the state exercises ownership is a state-owned enterprise. And ownership is defined in terms of control with full or majority voting rights or an equivalent degree of control.
Counsel, you are presenting two issues here. I just want to jump straight into these two issues. Number one is control, and number two is ownership. Can you please address these two issues to the tribunal directly, please?
Yes, Madam Arbitrator.
Thank you.
Thank you. Ma'am, if you look at the present facts before us, it says that the Bunuru government always maintained a sizable stake in the company, which ranged
So
from...
Which page in the bundle, please?
Ma'am, paragraph number 10, page 29 of the problem.
29.
Are learned arbitrators with me?
Yeah, I'm at that page, yeah.
It says that Bunuru government had sizable stake in WEMA as an entity, which ranged from 31 to 38%. And that is the ownership structure, which is a significant minority holding it had. And now if you look at paragraph number 8, again, page 29 of the problem, the inverted commas paragraph, it says that the Bunuru successor will be directed to ensure that it operates on the most remote islands. This shows, learned arbitrator, that apart from the significant minority shareholding that the government of Bunuru had in WEMA, it also had continued state control over it. And that is what lays down the ground before us.
Counsel, I wonder whether you are mixing these two concepts. One is control, the other one is ownership.
Madam Arbitrator, I apologize if I wasn't clear earlier. If we look at simply the ownership structure, it was 31 to 35%. And if we look at the control, there are various multiple facts present before us, which clearly says.
Yeah, so let's deal with these two main issues separately. If you say the ownership that the government has 35%, right? I mean, the government doesn't really have a majority ownership in this company, does it, or did it?
Madam Arbitrator, I would like to answer or clarify your concern in a two-pronged manner. First, that there exists no official definition as to identify what constitutes a state-owned enterprise. Therefore, reading in all or in conjunction with the definition we have, which is, it is not a hard and fast rule that if the minority stakeholding exists, then the government or any state for that matter cannot exercise control over an entity. And
are
therefore,
you saying, Counsel, are you saying that ownership is not defined anywhere?
Madam Arbitrator, there exists no official definition for the same. However, there are some material which gives us the definition for ownership, which is that with ownership that mentioned in the OECD guidelines for corporate governance, which says that ownership is defined in terms of control with full or majority voting rights. And that is why we're saying, or an equivalent degree of control. Therefore, here, the equivalent degree of control always existed with the government of Bunru over them.
But what about ownership, Counsel? You are moving to control now. I'm still wondering, how can you establish that the company is controlled, or maybe even solely controlled, or significantly controlled by the state?
Ma'am, if you look at the Articles of Association, page 46 of the problem, point 152.4.
Hold on, yeah, page 46.
Yes, ma'am.
Yeah, which paragraph?
152.4 point.
That is about the non-executive director of the company. I mean, how come this, the provision for non-executive director would be relating to or pertinent to your question of control, to your issue of control? I mean, director is a company's, operating officer, but control, so, I mean, what's the relevance between your issue and this paragraph?
Madam Arbitrator, as I pointed out to the Article of Association with respect to the government official being included in the board of directors, conjunctively reading that member of the tribunal with the facts before us, which is that from the significant holding and the presence of a government official in the board of directors clearly paints a picture before us that yes,
I see this sentence here in paragraph 152.4. It says the Ministry of Transport and Tourism shall nominate one of its officials for the non-executive director position. Do we know at all that any directors of the company was nominated by the Ministry of Transport and Tourism in the facts? Do you have facts?
Yes, Madam Arbitrator. Ms. Sabrina Blue was appointed as the Ministry of Transport and Tourism. And here, if you look at paragraph number 28, page 32 of the problem, which brings me, as I'm running out of time, Madam Arbitrator, I may direct you with the facts while pleading my submission here, that with respect to the functional analysis aspect, here it was always the government-related functions which predominated WEMA's operations. And we have multiple facts present before us. First, that if you look at
please present the facts. Thank you, Counsel.
Thank you, Madam Arbitrator. If you look at paragraph number 28, page 32 of the problem, it says that one of the pillars of Kelly Airways was to cater to the customers traveling from Mikar to Bunru, and also later in 2011, Horizon 2020 scheme was unveiled. And a key part of the scheme was to offer recurring subsidies to companies investing in tourism-related infrastructure. And WEMA was the first company which received that subsidies, member of the tribunal. And hence, we clearly present a position before you that it was the governmental functions which always predominated WEMA's operations. If that clarifies your concern, Madam Arbitrator.
Yeah, please proceed. Thank you for this point. Thank you.
Thank you, ma'am. Here, with respect to my first issue, I would like to submit that the tribunal does not have jurisdiction to hear the claimant's case because WEMA's conduct was always attributable to the state of Bunru, which classified...
Sorry, Counsel, but what about ownership? I mean, you may persuade me that the government indeed had control over the company, but what about ownership?
Madam Arbitrator, if I understand your concern correctly, here with respect to the ownership structure, even if you look at clarification number 3, page 86 of the problem, are members of the tribunal following me?
Yeah. I am.
It says that for some of the meetings, even the Bunuru representatives constituted majority. Members of the tribunal, this proves our point, or my point here, that even apart from that significant minority stakeholding, the Bunuru representatives were in majority. And
yeah, and do we know when, I mean, from which date or year that the majority ownership became owned by the government? Do we know the timing at all?
Madam Arbitrator, with respect to the timing, that we have been contending that from its inception, only VEMA has been a state-owned enterprise. Therefore, even there was any change in the ownership structure later, that is also important. However, from the beginning itself, we have laid down the ground before you that VEMA was a state-owned enterprise. So from the initial,
can you address the ownership change, please, to the tribunal? Because we think that might be an important factor for the tribunal to consider.
Madam Arbitrator, here the request for notification was registered as well as received on 17th November 2020. And that is the date for deliberation, and we understand that. And we also agree to
what is the situation of ownership before?
Madam President, I'm sorry to interrupt, but the time is up. If the other members of the tribunal are fine with it, I think agent might also be reserved 1 extra minute, because should have also gone through the second submission, the second point of, if everything is fine with you, I would also count an additional minute.
Please allow me, members of the tribunal.
Thank you, my co-arbitrator. Yeah.
Okay.
Please proceed, Counsel.
Thank you, Madam Arbitrator. Just to clarify your concern here with respect to the ownership also, Madam Arbitrator, as I was telling you about the date of deliberation, which becomes 17th November 2020, we agree that the change in the ownership structure happened later. However, from the very initiation, we have been submitting that from the inception, only VEMA has been a state-owned enterprise, which becomes clear before us because of 2 facts, that it also had significant shareholding in the VEMA, and also there was a presence of government official in the board of directors. And that is how, conjunctively reading that, it clearly presents a picture that with the significant minority holding, it also had continued state control over VEMA. And that I have also clarified that even in the particular instance from where this claim is arising, even that scenario, VEMA's conduct is to be attributed to the state because it was actually furthering the public interest of the government of Bunuru. And if that further clarifies your concern, I'll move on to my second issue with respect to the admissibility of an amicus applicant. Here, the relevant. Do I sense a concern, members of the tribunal?
But extra time is up.
Yes, extra time is up. It was 1 minute extra time.
Thank you, Counsel.
Thank you, members of the tribunal. It was my pleasure to plead before you.
Thank you. May we please have the claimant team, please?
Greetings, members of the tribunal. I hope I'm audible.
Yes, it is. Thank you.
Greetings, members of the tribunal. I'm Devika Rala, and in the next 19 minutes, I will be addressing the procedural issues before you today, whereas my colleague, as earlier introduced, Manasi, would be addressing the merits of this case. Members of the tribunal, this dispute concerns the claimant, which is a company involved in the airline industry for many decades now, and its investment in Kaili Airways, a major national airline in the respondent state. While the respondent state considered many factors, such as the claimant's relationship with the state of Bunuru, as well as its association with Moon Alliance, to be advantageous factor while permitting its bid to invest in Kaili, throughout this proceeding, you will see that the respondent state uses these very same factors to take actions that negatively affect the claimant and its investment. As we will be arguing before you today, this leads to a violation of the FET standards laid down in SETA and ultimately forces the claimant to sell its stake in Kaili back to the respondent in 2020. And this forms the crux of this proceeding. In this regard, I will be making 2 major submissions. Firstly, with regard to jurisdiction, and secondly, with regard to the admissibility of amici submissions. Coming to jurisdiction, members of the tribunal, we submit that this tribunal has jurisdiction under Chapter 9 of SETA and Article 2 of the ICSID Additional Facility Rules, since the claimant is not a state-owned enterprise, and even if it was considered to be one, They are not excluded from the ambit of SEPTA or the additional facility rules. Members Tribunal, for the sake of convenience, I will be mirroring the arguments raised by my opposing counsel and proceeding in the same order. Firstly, with regard to the exclusion of state-owned enterprises, members of tribunal, it is indeed not true that state-owned enterprises are excluded from exit jurisdiction. States are indeed excluded. However, the exclusion does not extend to enterprises that are owned or controlled by a particular sovereign state. And this is exactly what the Brochure's test, which my opposing counsel relied on, provides. The Brochure's test starts by saying that a state-owned enterprise or a mixed economy enterprise will have standing before exit tribunals unless they've performed essential government functions or acted as an agent of the state. Therefore, the questions as to whether the claimant company was owned or controlled by the state of Bondu will have no repercussions as to their standing before this tribunal. Is there a question?
Yeah, counsel, can you please address the tribunal whether your client has indeed acted as an agent of the state, please? Thank you.
Yes, yes. Thank you, Madam President. Now, in determination of whether a claimant or an investor has acted on behalf of another state or as their agent, the relevant test is the Brochure's test itself and its interpretation in BUCG versus Yemen, as well as CSOB versus Slovakia, and not the functional test that my opposing counsel has referred to. The function.
Agent,
yes.
allow me to interrupt you there for a second, though. Will you agree with the counsel of the opposite party that you will be bound by the test that you're presenting now?
The Brochure's test will be of extreme use to this tribunal to determine whether the claimant was a state or not. However, this tribunal is not bound by the Brochure's test, since the Brochure's test was formulated in the context of exit convention, whereas this proceeding is being pursued under exit additional facility rules.
Let's assume, counsel, that this was made under the exit convention. Will it be binding then?
Mr. Arbitrator, I believe it would be, because the Brochure's test is directly derived from the preparatory work of the exit convention.
So can you please elaborate on what you consider to be the binding nature of international arbitral awards?
Yes, Mr. Arbitrator, I believe this tribunal is not bound by the previous decisions of exit tribunals, and also to an extent not by the preparatory work. However, the Brochure's test being derived directly from the preparatory work, it would be instrumental in determining issues in this particular dispute. Allow me to correct myself. This tribunal is not bound by the test or the preparatory work. If that answers.
I'm confused. I think
Yes.
it's two different things. I'm sorry.
Yes, Mr. Arbitrator, this tribunal is not bound by any of the previous exit tribunal decisions that may be cited as precedents, and it's not bound by any of the decisions.
Then what's the use of quoting tribunal decisions then?
Members of the tribunal, these decisions that were being taken by previous exit tribunals have extreme resemblance in the factual circumstance as well as the investment treaties, and may be instrumental in deriving a conclusion as to the principles applicable, but the tribunal is not strictly bound by any of those decisions.
Continue, Agent.
Proceeding with my arguments, members
Counsel?
of the tribunal. Yes.
Sorry to interrupt. So you mentioned also the SEPTA. Could you please guide this tribunal to the relevant provision that should lead us to understand whether state-owned enterprises should or should not appear before the tribunal itself? Thank you.
Yes, Mr. Arbitrator, thank you for your question. This actually takes me to my next submission. You can find the definition of investor as well as enterprise on page number 73 of the case record. Page number 73 of the case record has Article 9.1 of SEPTA, which provides the definitions, and on line number 2590, it has the definition of investor, and I quote from the definition: investor means a natural person with the nationality of a party, or an enterprise with the nationality of a party or seated in the territory of a party. The claimant in this proceeding is an enterprise, and the definition of enterprise is also provided in the next line, clause number A, an enterprise that is constituted or organized under the laws of the party and has substantial business activities in the territory of that party. Members of the tribunal, the definition of investor or enterprise as provided in SEPTA has no exclusion that is based on ownership or control by another sovereign state. This only furthers my argument that state-owned enterprises are not excluded under the addition facility rules or the SEPTA. Proceeding with the question of essential government functions and agency, members of the tribunal, as I've already demonstrated before you today, ownership and corporate structure are not relevant in determination of these issues. And the question of functional test that my opposing counsel has pointed out is not the right test to be applied in this decision. The functional test is used only to determine whether the wrongful acts of a state-owned enterprise are attributable to a respondent state. The functional test is not used to determine the standing of a state-owned enterprise's claimant. Yes.
Counsel, do you find a basis for this test? Does you believe it's right under public international law?
I believe you're referring to the functional test, Mr. Arbitrator?
Yes.
Yes, the functional test is derived in light of Article 8 of the draft ILZ articles. And
is that treaty law, customary law? What kind of international law is it?
It is not customary international law, members of the tribunal, and this tribunal is not bound by the
ILZ
same.
articles are not customary international law.
No, members of the tribunal.
Okay, continue.
Proceeding with my arguments, members of the tribunal, the functional test is usually used to determine whether a state-owned enterprise is a respondent in a particular dispute. This dispute, however, concerns the standing of a state-owned enterprise as a claimant, and the relevant test is Brochure's test as elaborated in the decision of BUCG versus Yemen. Now, the Brochure's test provides that the relevant question for determining their standing is whether the state-owned enterprise discharged any sovereign functions while undertaking the investment activity in the host state. It's not relevant whether the claimant or the investor has undertaken certain acts of public nature in its home state. Furthering this, members of the tribunal, the Brochure's test also provides that in determining whether there was discharge of essential government functions or agency, it is critical for the tribunal to examine the nature of the activities that were being undertaken by the claimant or the investor and not their purpose. Members of the tribunal, this particular claimant and its investment in Kaili Airways and related activities have always been commercial in nature, starting from the bidding process in 2010, where it participated in a competitive bidding process along with 3 other companies, and its following decisions taken with regard to Kaili in the following years, all were based on commercial reasoning. Even the decision of the investor to sell its stake in Kaili in 2020 was based on a perfectly commercial reasoning that the investment was proving to be non-viable and it was making extreme. Is there a question, Madam Arbitrator?
Yes, Counsel, can you address and respond to the respondent's counsel's submission in regard to number 1, ownership, and number 2, control, please, in relation to your client's company? Thank you.
Yes. Yes, Ambassador. Thank you very much for the question, Madam Arbitrator. With regard to ownership, the claimant company was, the state of Bondu had an ownership of 31 to 38% throughout for all the dates that are relevant for this tribunal's determination on jurisdiction. And I believe my opposing counsel pointed you out to page number 46 of the case record, which provided for the appointment of a director. Members of the tribunal, if you're with me on page number 46, it provides that the state of Bonadu is in charge of appointing one of the directors on claimant company's board, whereas if I refer you to 152.2 on the same page, it reads that the board of directors has 8 different directors. Members of the tribunal, the mere fact that one of the directors in a board that consists of 8 directors cannot possibly mean that the state exercised control over the decisions that were being taken by the claimant's board.
Do we know what is the function of this specific nominated director at all in relation to the business going concern of this company?
Yes, members of the tribunal, we do not know the exact nature of the functions that was being performed by the non-executive director. However, the description of the non-executive director is provided in 152.4. We believe as in our understanding, the role of this director was to represent the interests of the state of Bondu in the claimant company, but this did not translate to control over the activities of the company.
And this director is non-executive, isn't it? It's acting in the capacity of not being an executive director.
Yes, right,
Thank you.
Madam Arbiter. Yes. I would also like to address the point of Sabrina Blue, as was raised by my opposing counsel members of the tribunal, on page number 31 of the case record, paragraph number 22. I believe there was a misunderstanding as to facts of the case where my opposing counsel pointed that the Sabrina Blue was acting as the secretary of Ministry of Tourism while also acting as the head of board, whereas this paragraph number 22 specifically provides that Ms. Sabrina Blue, erstwhile head of WEMA's board, she was not performing these two roles simultaneously. She was only a previous head of the board of directors in the claimant company. I hope this answers the questions with regard to ownership and control, members of the tribunal. However, regardless of the fact that this claimant company is not a state-owned enterprise, ownership and corporate structure are not relevant in determining the status of the claimant company as an investor, as is clear from Article 9.1 of SEPTA. And I believe I also argue that the claimant has not performed any essential government functions, since the underlying nature of the activities is undertook in the respondent state was always commercial in nature. I see that I'm approaching 12 minutes, members of the tribunal, so I will proceed to address issue 2 in this dispute, which concerns the admissibility of the amici submissions received by this tribunal. Firstly,
could you please enlighten this tribunal with the difference between admissibility and jurisdiction?
Yes, members of the tribunal. In this particular dispute, the admissibility question is not related to admissibility of the claimant's a notice of arbitration. This is only with regard to non-disputing party submissions, which is not relevant in determination of this tribunal's jurisdiction.
But my point being the general difference between admissibility and jurisdiction as general notions applicable in international investment arbitration.
Yes, Mr. Arbitrator, to answer your question, the question of jurisdiction is related to standing of an investor or any other claimant before an exit tribunal, whereas the question of admissibility is a question of maintainability of the proceeding as a whole. So jurisdiction relates specifically with reference to the claimant's position or the person who initiates the dispute, whereas admissibility is in relation to the entire proceeding and its maintainability before an arbitration.
But then I have a follow-up question there. So what if there was no investment? Will that affect jurisdiction or admissibility?
If there was no investment, that would affect the jurisdiction of the tribunal, since
so
it's
then,
an investor.
So then how it's not related to the party? It's having a hard time grasping the
yes, I believe the jurisdiction is the jurisdiction arises from the question of whether a concerned company was an investor and undertook a particular investment activity. Therefore, it would be in direct consonance with the question.
And I believe the counsel that you're referring to the notion of jurisdiction ratione personae. That's correct. But how about the other notions of jurisdiction? For instance, ratione materiae.
Yes, Mr. Arbitrator, the question of ratione materiae also relates to jurisdiction of the tribunal and the attributes of the particular claimant in a dispute.
How is that an attribute to the particular claimant?
Can you repeat your question, Mr. Arbitrator?
How is the nature of the existence of one investment related to the claimant as party?
Yes, Mr. Arbitrator, I believe the question of ratione materiae relates to the existence of an investment and a legal dispute in relation to that investment, and therefore would be in direct connection with the standing and the standing of a claimant as an investor.
Continue.
Yes. Proceeding to issue number 2, members of the
Counsel.
Yes.
A question. It's
yes.
a follow-up, a bit unrelated, but which is the test that the tribunal should use to determine whether a particular fact patterns constitute an investment itself?
Yes, members of the tribunal. I believe the tribunals usually refer to the Salini test to determine whether there was an investment, which has 4 major factors of contribution, risk, and two more factors. But this is not in contention in this dispute. So if I may proceed with my arguments in issue 2.
Yes, just a brief follow-up. So, but this is not an exit arbitration, right? It's done pursuant to the additional facility. Should we apply this test as well in the current case? What I mean, it is a yes/no question.
Yes, it is usual. Yes, Mr. Arbitrator, it is usual. Although there is an exclusion of all the material of exit convention in proceedings that are undertaken under additional facility rules, it is usual practice for exit additional facility rules tribunals as well to follow certain tests that are formulated by exit tribunals when there are similar provisions that exist in the exit convention and the additional facility rules.
Thank you, which also brings up to the main question, my colleagues, whether precedents and other arbitral awards carry any value of precedent in international investment arbitration. Thank you. Please proceed.
Yes, thank you very much. Members of the tribunal, with regard to admissibility of the 2 amici submissions, it is our submission that firstly, the submission from CBFI ought to be accepted and that the external advisor submission ought to be barred. Firstly, with regard to the CBFI's non-disputing party submission, members of the tribunal, it does satisfy all the criteria that is laid down under 41(3) of the additional facility rules, as well as constitutional transparency rules, and the relevant provision, which is Article 9.19 in SEPTA. And I believe the respondents had raised certain objections as to independence in their submission before this tribunal, and it is our contention that the claimant's membership in itself is not sufficient to challenge the question of conflict of interest or independence, and neither is the participation of Lapras Legal Capital in this proceeding, since Lapras Legal Capital has no financial interest in this particular arbitration proceeding. They have merely advise the claimant as to funding strategies that may or may not be adopted. They do not have any financial interest in this proceeding, and therefore it does not lead to a conflict of interest. Secondly, members of the tribunal, the CBFI also assists this tribunal by providing a unique perspective that the claimant or the respondent is not in a position to provide this tribunal. Thirdly, lastly, with regard to the external advisor submission, members of the tribunal, we ask this tribunal to not entertain this submission since the concerned amici have no significant interest in this proceeding, which is an essential criteria under the additional facility rules.
Counsel, time is up. Time is up.
Oh, all right. Yes, members of the tribunal, that leads me to my ending conclusion, which is that we request this tribunal to admit the CBFI submission and not entertain the submission of external advisors. Thank you.
Thank you.
Thank you, Counsel. May we now please move to the next stage, which is the substantive issues of this session, please. I believe that the claimant team will proceed first. Is that the case?
Madam President, I think we had agreed to the format that R1, C1 will be pleading, followed by rebuttal and sur-rebuttal. So I believe the respondent team will be responding to the claimant submission.
Yeah, you are right. Yes, I forget about that. Yes, rebuttal, please, if the respondent would wish to rebut.
Yes, Madam President, if I may proceed. First, my opponent counsel has stated that we can't rely on Broche's test, and because it is a part of exit convention and not AFR. Here, members of the tribunal, AFR is a limb of exit convention itself, and we relied on the drafting history of the convention, and the authority to rely on that is derived from Article 32 of VCLT, which says that the recourse can be made to supplementary means of interpretation. Second, members of the tribunal, they mentioned the BUCG case. Here, the tribunal stated that the context-specific analysis has to be made. Here, in the present dispute, the state-sponsored violation of competition law is exactly the place from where the claim is arising. Hence, we submitted that it is the governmental function which predominated WEMA's operation. Third, they stated that the state exercised control, and that is why the state-owned enterprise can be included within the ambit of exit convention. Members of the tribunal, if the state exercises control or has ownership in the entity itself, which means that the conduct of the entity can be attributed to the state, which makes this dispute a state-to-state arbitration. And they have, with respect to the amicus issues, they have stated that there existed no independence. Members of the tribunal, Lapras Legal is advising WEMA in respect of its claim against
Agent,
federal.
time is up. Please conclude.
I was just stating the last point, members of the tribunal, that here the independence criteria exist because Lapras Legal is advising WEMA in respect of its claim against Federal Republic of MICAR itself. So participation of Lapras Legal through CBFI clearly raises a conflict of interest. Thank you.
Any rebuttal?
Yes, members of the tribunal. Firstly, with regard to Broche's test, the additional facility rules are in fact not a limb of the Exit Convention. It specifically falls outside the ambit of Exit Convention, and Article 3 of the additional facility rules provides that any material or any cases that are relevant for interpretation of the Exit Convention is not applicable for proceedings under additional facility rules. Secondly, with regard to the BUCG versus Yemen case, members of the tribunal, it is right that it is required to contextualize the relevant facts. But even in the decision of BUCG versus Yemen, when the claimant was a 100% Chinese-owned company, the claimant was provided standing before the tribunal. Lastly, with regard to the question of Lapras Legal Capital, members of the tribunal, they have merely advised the claimant as to funding strategies. They have not funded this particular proceeding, and that means that they have no financial interest in this arbitration proceeding. Thank you.
Thank you, Counsel. I think we now move to the substantive stage, and I believe that the claimant will proceed first. Thank you, Counsel. Please proceed.
Yes. Greetings, members of the tribunal. As already introduced by my co-counsel, my name is Mansi Desai, the second speaker representing the claimant. In the next 19 minutes, I shall be addressing two issues on the merits of the dispute. Issue 3, concerning the violation of fair and equitable treatment standard, and issue 4, regarding the appropriate standard of compensation applicable. Article 9.9 of SEPTA casts an obligation upon the respondent state to accord a fair and equitable treatment standard at all times, and the same has been provided for on page number 76 of the case record. Under issue 3, the claimant will primarily be making two submissions. In my first submission, I shall be addressing each of the individual violations under SEPTA, that is, the respondent had caused a denial of justice, discriminatory conduct, and abusive treatment. And in my second submission, in the alternative, the claimant contends that the tribunal may also consider the cumulative effect of all the breaches considered together to constitute a creeping FET violation. Proceeding with my first submission under issue 3, there was denial of justice before the MICAR courts, which was a violation of Article 9.9, paragraph 2, clause A of SEPTA. And this is evident from the multiple instances when the claimants had sought redress from the MICAR judiciary. But on most of these instances, its requests were either delayed or denied completely. As observed in the case of Robert Azinian versus United Mexican States.
Agent, will say that the denial of justice is a standard recognized by customary international law.
If I understand your question correctly, you are asking regarding the standard of denial of justice under customary international law. Is that correct?
Yes.
Yes. Yes. So the standard of denial of justice is extremely high, I'm afraid. However, in the present dispute, the claimant is contending that this high standard is met considering the cumulative violations of all the...
Okay, it might be high, but are we referring to the one under customary international law or the one under the treaty? And what's the relationship between both?
Mr. Arbitrator, no such specific standard has been mentioned under SEPTA concerning denial of justice. However, in general terms, the standard of denial of justice is considered to be extremely high, which is why in the alternative, claimant shall also be contending that if...
Let's keep it to a yes or no question. Would you say that the standard of denial of justice is recognized by customary international law? Yes or no?
Yes.
And is it different, if so, is it different from the one contained in the treaty, the SEPTA?
No, it is not different, as SEPTA does not have any express provisions concerning the standard of denial of justice. If I may be allowed to proceed. Yes. So I will be establishing the denial of justice claim through a series of events, which I will be highlighting. Firstly, Kylie had sought an urgent hearing against the imposition of airfare caps, and this urgent hearing could only be scheduled 1 year after the registration of claim. And secondly, even when a hearing was scheduled, in paragraph 54 on page number 38 of the case record. Yes.
Do we know why the urgent hearing could only be scheduled 1 year after? What is the reason?
The reason being that Mekari judiciary generally prefers to prioritize criminal matters over civil matters, as is evident from the uncontested facts. And it,
so in that
is there an
sense,
addition?
yeah, I mean, so if in that jurisdiction, in their country, the judiciary would normally be prioritized for, say, criminal or civil matters rather than maybe commercial matters, let's say, would that say that this delay is deliberately targeting your company, you know, your client's company at all then? I mean, I'm not persuaded to see that this is, yes, there might be a delay, but this delay, I'm not persuaded that this delay is particularly targeting your client's company.
Madam President, I started my contention with the undue delay claim, as I was merely trying to build my case. That is, even when a hearing was scheduled, the matter was prematurely dismissed, and even Kylie's application on merits was also dismissed in the same hearing on interim measures. And under Mekari law, there is no further right to appeal. And even when the claimant had appealed against the CCM orders, its hearings were only scheduled a year and a half after the registration of claims in May 2020, but a written decision was never released. And proceeding to my next submission under denial of justice.
Agent, so just to follow up on Madam President's question, then you're saying that the standard of denial of justice is extremely high, and then you're applying directly customary international law. If that's the case, then how would you relate that to Article 992A of the SEPTA?
Yes, Mr. Arbitrator, this leads me to my next contention, which is that Article 36, paragraph 1, clause E of the Commercial Arbitration Act of Mekar, read along with Article 5, paragraph 1, clause E of the New York Convention to which Mekar is a party, states that such awards which have been set aside at its seat should not be recognized and enforced. But in ignorance of the domestic law provision, as well as the International Law Convention, the High Commercial Court of Mekar recognized and enforced an award which was already set aside by the Supreme Arbitral Court at its seat. And subsequently, when claimant sought an appeal against the High Commercial Court's order, its appeal was also dismissed. Members of the tribunal, I would like to highlight that this award was only set aside on the grounds of bribery and corruption allegations. And I would also like to place reliance on the case of Chevron versus Ecuador 2, in which the
I'm sorry, I believe you didn't answer my question.
Yes, I'm just coming to that, whether the standard has been breached or not. In Chevron versus Ecuador, where the judgments of the domestic courts were ghost-written and there was procedural fraud in rendering the decision, the tribunal had observed that that denial of justice construes when there is a failure on part of the national judicial system itself. And in the present dispute as well, the claimant is contending that cumulatively, if we were to consider all of these measures, the entire Mekari judiciary had failed to render justice. And therefore, the claimant submits that the high threshold of denial of justice has been met, as no competent judge would have rendered a decision such as the High Commercial Court of Mekar in recognizing and enforcing an award which was already set aside at its seat based on bribery and corruption allegations. Proceeding with my
I mean, these are strong allegations against the judiciary of that specific jurisdiction. Do we have any evidence, specific evidence regarding corruption and procedural fraud, as you just alleged? I mean, are these if there are evidence there, are they in the bundle at all?
Yes. If members of the tribunal were to refer to Annexure 7 of the case record on page number 61, this is a report.
Hold on, page
Yes.
61.
On page number 61, this is a report by Center for Integrity in Legal Services in which...
Paragraph. Oh, is there any specific paragraph there?
No, the entire Annexure 7 concerns with the bribery and corruption allegations in which a report was released citing that in which the CILS is making observing that there was in fact bribery and corruption while rendering the Steno Chamber of Commerce decision as the...
So I see this report, but do we know what is the background of the making of this report?
Madam Arbitrator, I'm afraid the background of the making of this report has not been contextualized. Also, in the interest of time, I would like to proceed with my next contention, which is there was discriminatory conduct in violation of Article 9.9, paragraph 1, clause C. If members of the tribunal were to refer to page number 36, paragraph 46 of the case record.
Yeah.
Here, an Executive Order 9 of 2018 was passed, wherein foreign airlines such as JetGreen and Starwings were granted subsidies, whereas Kylie's application for grant of subsidies was rejected, and no reasons were furnished for the rejection of the same. Whereas all these airlines, JetGreen, Starwings, as well as Kylie, are entities in like circumstances, but they have been, as JetGreen and Starwings also have holding companies located in Arrakis and are also receiving subsidies from their home country, which are even greater than those received by Kylie. But Kylie's application was still rejected without furnishing any reasons. And this constitutes a discriminatory conduct. Proceeding with my next submission, which is that the claimant's investment was subjected to an abusive treatment in violation of Article 9.9, paragraph 2, clause D. For this, I would like to direct the tribunal's attention to page number 34, paragraph 36.
Yeah.
Where, yes, here CCM had launched a suo motu investigation into the activities of Kylie. However, Annexure 5 of the MRTP Act, which has been given on page number 47, chapter 3 of which states that such investigations can only be launched when the market share of the entity is greater than 50%. However, at the time when this investigation was launched, Kylie's market share was only 43%. And CCM had arbitrarily considered its market share to be greater than 50% in conjunction with its Moon Alliance partner, Royal Narnian. Whereas in paragraph 25 of the case record, if I may direct the tribunal's attention to page number 32. Here, paragraph 25, CCM had already pre-approved the Moon Alliance membership of Kylie and had also made them sign an undertaking regarding the same. But subsequently, CCM frustrated this approval which was given by it, and it initiated the investigation, which is in violation of the MRTP Act provisions itself. And members of the tribunal, this was merely done so in order to harass the claimant. And this is also evident from the fact that during the Macquarie currency crisis, Kylie had repeatedly requested CCM to reconsider the imposition of airfare caps. However, CCM denied its request. But subsequently, if tribunal members were to refer to page number 40, paragraph 64 of the case record, here, the moment the claimant's stake in Kylie was sold to the respondent, CCM suddenly factored in the economic distress faced by Kylie and decided to waive off all fines. And this further supports my contention that there was undue harassment of the claimant's investment. Proceeding with my second submission under issue 3, which is that, do I sense a question?
No.
All right. Proceeding with my second contention under issue 3, which is that in the alternative, the tribunal may also consider the cumulative effect of all these violations taken together and the authority for the same can be construed from the El Paso versus Argentina decision, in which the ICSID tribunal had considered the cumulative nature of all the breaches, although there were no individual violations as such, and ruled in favor of the investor, saying that there was in fact an FET violation. And in the present dispute as well, measures such as initiation of investigations, imposition of airfare caps, imposition of fines, passing of decrees and executive orders, all of these measures may also be considered together to constitute a creeping FET violation. If tribunal, and to conclude with issue 3.
But agent, I thought that the notion of creeping violation was only exclusive to expropriation.
Mr. Arbitrator, indeed not. In El Paso itself, the tribunal makes a distinction between the notion of creeping FET violation and a creeping expropriation violation. And if I may cite from the from paragraph 518 of the judgment of the award itself, in which the tribunal also went ahead and defined a creeping FET violation as a process extending over time and comprising a succession or an accumulation of measures which taken separately would not breach the standard, but taken together do lead to such a result. And if tribunal members have no further questions, I would like to conclude with issue 3 and proceed with issue 4.
I do have a quick question indeed. Please, can you guide us to the relevant provision, if any, in the treaty between Bonoro and Mekar, so the SEPTA, whether there is any wording, for instance, that might guide this tribunal to understand whether we might consider a creepy violation of the FET standard? Thank you.
Yes, Mr. Arbitrator, this is apparent from the wordings of paragraph 2, article 9.9 itself, wherein the drafters have used the phrase measure or measures, which means that the—
Can you please, sorry, can you please get the tribunal also to the relevant page and paragraph?
Yes.
Thank you.
Yes, I apologize. It is page number 76 of the case record in paragraph 2, article 9.9, wherein the drafters have expressly used the term measure or measures, meaning thereby that all the measures can also be construed together to constitute an FET violation. To conclude,
Thank you.
To conclude, there has indeed been a FET violation as the respondent has caused a denial of justice, discriminatory conduct, abusive treatment of claimant's investment, and in the alternative, the tribunal can also consider creeping FET violation. Proceeding, do I sense a question? Okay. Proceeding with my issue 4. Issue 4, members of the tribunal, concerns with the appropriate standard of compensation which will be applicable in the present dispute. And it is the claimant's contention that this appropriate standard should be the fair market value standard. And for this, the claimant is placing reliance upon the most favored nation treatment clause, which is given under Article 9.7 of SEPTA on page number 76 itself of the case record. And Article 9.7, which is most favored nation treatment, requires a comparison to be made between two investment treaties. And in the present dispute, the claimant seeks to make a comparison between Arrakis-Mekar BIT and the SEPTA. Article 13 of Arrakis-Mekar BIT, which is given on page number 84 of the case record. Article 13 states that compensation should be payable at fair market value and the position of the claimant before the measures inconsistent were taken. Whereas Article 9.21 of SEPTA, given on page number 82 of the case record, states that—
Can you please address the tribunal, what is the difference between the fair market value and market value?
Yes.
I mean, if you try to persuade the tribunal that the fair market value should be adopted in considering quantum,
yes,
what's the difference between these two in your case?
Yes. To answer your question, I would like to cite an internationally recognized definition of fair market value, which was also cited in a couple of ICSID decisions, such as Tempra International versus Argentina, CMS versus Argentina, to name a few. In this, fair market value has been defined as the monetary equivalent of the transaction in an open, unrestricted market between a hypothetical buyer and a seller. Whereas market value standard refers to the standard of compensation which is agreed to between a buyer and a seller on a certain valuation date. And in the present dispute, the $400 million purchase price may be construed to refer to the market value standard. However, it is the claimant's contention that this market value standard is not appropriate to compensate the claimant with the breaches that it had suffered. And I see I have almost exhausted my time. I request an extension of 1 minute to conclude issue 4.
Yes, please.
Yes.
Yes,
1
proceed.
minute. Thank you, Counsel.
In the present dispute, the fair market value standard should be more appropriate, and compensation is also something which falls under the category of treatment under paragraph 1 of Article 9.7 arising out of sale or disposal of assets, and also observed in the decision of Guris versus Syria, wherein the war loss clause compensation was treated as treatment. Therefore, the compensation in the present dispute should be at fair market value. The claimant rests his case. I'm sorry. Yeah.
Thank you, Counsel. Now we move on to the respondents' submission on the substantive issues. And of course, could you please respond to the claimant's counsel submissions first? Thank you.
Absolutely. Thank you so much, Madam President. Members of the tribunal, as previously introduced, my name is Counsel Submissions. I will be making submissions on behalf of the respondents on the issues of merits and compensation. And I will be moving very structurally as the structure laid down by the claimants, mirroring their speech for the benefit of the adjudication by this honorable tribunal. Members of the tribunal, but before I start, allow me to make an analogy for your convenience. If tomorrow the honorable tribunal decides to open a bakery, and if I were to invest in that bakery, and subsequently we start making some profits, but after some time, I start taking anti-competitive actions. I start buying fanciest of the chandeliers, even when the tribunal is asking me, Kostub, please pay attention to the kitchen, please pay attention to the debts, but I don't pay heed to any of these requests and take all those anti-competitive actions. And when the economic situation goes down, I blame the honorable tribunal for all the losses that have been done because of my faults. Members of the tribunal, there are two major claims raised by the claimants in the instant case. Firstly, that there has been a violation of the Article 9.9, which we submit there hasn't been. And secondly, since there is no violation of Article 9.9 of SEPTA, there is no compensation payable from the side of respondent to the claimants. And even if this honorable tribunal is to find any such compensation payable, should be amounted on the lines of market value, wide the principle of lex specialis, since the treaty makes a specific provision for the same. Beginning with the first submission, members of the tribunal, let us see what are the major submissions that have been highlighted by the claimants. There are 4 major submissions with respect to the breach of Article 9.9, members of the tribunal, beginning with the first, that is denial of justice, secondly, discrimination, thirdly, the abusive treatment, and fourthly, the cumulative effect of all these various instances and how that breaches the international obligation. Beginning with the denial of justice, members of the tribunal, we completely concur with the observation of the honorable tribunal that the standard for the breach of the denial of justice is extremely high. Now, the major contention raised by the respondents in the instant case is with respect to the undue delay. Members of the tribunal, if I may please draw your attention to paragraph number 29. And if the honorable tribunal is reading the case on PDF files, then the page numbers will be in one subsequent. So it would be page number 30, members of the tribunal. It's page number 29, para number 30, members of the tribunal. It clearly shows that there has been an exponential increase in the population of the country and has also increased the caseload as well as the congestion with respect to the courts. And the estimated period of time is about 27 months that the courts take to dispense the justice. Members of the tribunal, we rely on the understanding of the tribunals like White Industries versus India, where they have put forward various factors for the consideration while deciding on the issue of denial of justice. One of them being the complexity of the case, the backlog before the courts, the nature of the population, the nature of the litigation. In the instant case, members of the tribunal, it is extremely clear that there was 27 months of lag which was observed. Irrespective of this, we accorded a hearing to the claimants within a year, within 14 months, members of the tribunal. Mr. Arbitrator, is there a concern?
Yeah, allow me to redirect the question that I already made. With the difference between the denial of justice standard as indicated in the treaty, as opposed or as different or the same as it is in customary international law.
Mr. Arbitrator, we understand where this concern is coming from. The FET clause, as can be seen in Article 9.9, is enlisted like a shopping list clause, which can be read to be parameteria with the Comprehensive Economic Treaty Agreement between Canada and Europe. Unfortunately, members of the tribunal, I do agree with the submission of the claimants when they say that there is no specific standard set for denial of justice. But there is a high standard set by the international customary law, members of the tribunal. And the same standard should be interpreted as has been conceded by the claimants in the instant case. As we submit, members of the tribunal, in the instant case, there has been no undue delay because with respect to the injunctive application that was moved by the claimants, there must be an irreparable harm. And irreparable harm, members of the tribunal, is when the very existence or the market position of the claimants would come into question. In the instant case, there is no such irreparable harm. Secondly, we understand, members of the tribunal, there is a concern.
So I think my point taken. So I think it's what you're saying is very interesting. But then following up on that, is there not being a standard set in the treaty as such? Why would you apply directly customary international law? Because you may have noticed that some international investment treaties indicate expressly we will apply customary international law, whereas there's no indication here. So I think there is a gap that you will have to bridge for this tribunal.
Mr. Arbitrator, allow me to bridge this gap for you. If I may please draw the attention of the Honorable Tribunal at page number 76 of the hard copy, 77 of the PDF. If we read the Article 9.9, members of the tribunal, the heading of the article is minimum standard treatment. Members of the tribunal, it has been held by various scholars like Rumana Islam that the FET may be considered as an extension of the MST. But if you look at the various NAFTA standards such as near case, the MST in itself shows the international customary law standard of treatment, which is extremely high, members of the tribunal. With this, we move on to the subsequent submissions with respect to how the concern that has been raised.
Agent, I have a question. So just thinking, so you mentioned that the population in the country has been growing, and that might actually create some issues regarding the adjudicability of disputes. But should have a country that is eager to attract foreign direct investment also better its own judiciary, especially as regards commercial disputes, also considering potential disputes coming from foreign investors, so that to present and prepare, also to have a better reputation when it presents outside in the global world in order to attract more investments. Thank you. What's your take on it?
Indeed, Mr. Arbitrator, and we concede to the criticism, but we do not concede to the breach of the FET standard. Allow me to present to you one of the examples. In White Industries versus India, the execution of the award took 9 years before the judiciary of India, and it was still not held to be the breach of the denial of justice, although the tribunal did criticize the country of India for not having an efficient mode of judicial conduct. And with respect to the dispensation of justice, we agree, members of the tribunal, that we are a developing country. There is an exponential increase in the population and we are suffering with the backlog. And with all of these predisposed conditions, we understand that there has been some inconvenience caused to the claimants and we apologize for it, but there has been no breach of the treaty for which we can ever concede. In the instant case, members of the tribunal, allow me to demonstrate it with one of the secondary obligations that have been pointed by the claimants. The claimants have highlighted, members of the tribunal, that the enforcement of the award, the arbitral award set aside by the seat of the arbitration itself amounts to the denial of justice. In the instant case, members of the tribunal, firstly, we submit that this honorable tribunal very respectfully does not have the scope of inquiry to look into such question. Members of the tribunal, this honorable tribunal should not serve the purpose of a super appellate body. Secondly, with respect to the scope of inquiry, there needs to be a manifest misapplication and malicious misapplication of law, members of the tribunal. In the instant case, allow me to show the concern that the Madam Presiding Arbitrator asked the claimants as well, whether there is a validity with respect to the bribery cases or not. In the instant case, members of the tribunal, if I may please draw your attention to page number 64, that would be 65 of the reader, members of the tribunal. In the instant page number, members of the tribunal, it is paragraph number 11. And if I may please read with the honorable tribunal, it states that, however, the court has no doubt the international recognized portion CLS experts cited in its reports are in neutral impartial. However, the court rules on the first element of claimant's public policy argument, despite the weight evidence claimants, subsequent to which it holds that the claimant, including 14 June 2020 CILS report and the report of the independent experts appended to it, the court does not find itself in a position to conclusively rule whether the act of bribery had in fact taken place or not. This is the reasoning of the seat of the arbitration, members of the tribunal, and we have, as a court of enforcement, looked into this issue. Moreover, members of the tribunal, unfortunately, the claimants have accidentally misinterpreted and have misguided this honorable tribunal while reading Article 5(1)(e) of the New York Convention. They have said that when an award is set aside by the seat of arbitration, it should not be enforced by the host state. In the instant case, Article 5(1)(e) states that when an award is set aside by the seat of arbitration, it may not be enforced by the host state. The may in itself allows the discretion of the courts to look into the questions of law and questions of fact and then make a decision, members of the tribunal. With this, members of the tribunal, I also answer the concern of discrimination, wherein they have relied on various subsidies that were awarded. Members of the tribunal, the test laid down in Saluka Tribunal says that when the like circumstances are treated in different manners without any particular reasoning, in that situation, discrimination occurs. In the instant case, as my previous co-counsel Anjali has submitted, that we do not believe that the claimants are indeed anything but state-owned enterprise and they are performing the government functions. In the instant case, the reasoning provided was sufficient because that was the exact same basis on which we denied the subsidies to Larry Air, which also is a state-owned enterprise, members of the tribunal. Subsequently, there is a submission of abusive treatment with respect to the suo motu investigations, which again is unfortunately misapplication and misreading of the law by the claimants, members of the tribunal. If I may please draw your attention to the MRTBA Act. Just a second, members of the tribunal. It is on page number 47, 48 of the reader. Members of the tribunal, in chapter number 3, entry number 2, we see subsection A. It says a corporation obtains a market share greater than 50. The CCM may exercise discretion in industries that require special attention to open an investigation where a corporation owns a lower market share. The use of the discretion should be exceptionally rare. Now we'll show this honorable tribunal why there was a situation of more than 50% market share and why the discretion was required in the instant case. Now, if I may draw the attention of the honorable tribunal to paragraph number 25 of the fact sheet, which is at page number, one moment, members of the tribunal. It is at page number 32, members of the tribunal, which is 33 of the reader. Members of the tribunal, this again shows the misreading by the claimants where they selectively read the part of the paragraph and missed out on the other. When we say that we recognize the investment of the claimants, we also made a very specific representation. And if I may read with the honorable tribunal, the third last line. CCM sought an undertaking from KLE that it would not engage in high-level cooperation on competition parameters such as prices, schedules, capacity, facilities, etc., etc. In subsequent paragraphs, paragraph number 27, members of the tribunal, we look at the last line. Here, the claimants have given the undertaking where they have promised that in respect of the Moon Alliance members, especially the Royal Narnian, in respect of lounge access, terminals, ID performance, etc., etc., will be taken into consideration. Now, members of the tribunal, I rely on the OECD draft of the background paper for airline competition. In paragraph number 89 and 32, we see what is a low-level cooperation, what is a high-level cooperation, what is a mid-level cooperation. In the instant case, high-level...
Sorry to interrupt, but this being a draft document, how is this binding? How is this proper source of law for this tribunal?
Mr. Arbitrator, to in a way answer your concern that has been persistent for so long, there is nothing which is directly binding on this tribunal, members of the tribunal. We draw the applicability of such rules and laws by the virtue of section 54, article 54 of the ICSID additional facility rules, members of the tribunal. There are two things stated in that rule. Firstly, that the law that has been decided by the parties which will be applicable on the tribunal, in the instant case, the treaty law, and in subsequence for the interpretation of the same, the tribunal can make references to international law and other such various provisions. That again is discretionary in nature. And by my submission, I will convince the Honorable Tribunal why this draft does play a very significant role in this instant case and will convince this Honorable Tribunal. Members of the tribunal, we submit that the OECD draft with respect to the background paper on airline compliance competition clearly states that only high-level corporations will be considered anti-competitive. And that is what has been found by the CCM. So the claimants were supposed to answer the first principal question before questioning the Honorable Tribunal why there was no revision during the economic crisis. Was because why were the CCM caps imposed in the very first place? And secondly, members of the tribunal, the economic crisis exists for everyone, smaller participants in the market as well. This is one participant, that is the claimants, which is dominant in the figure, driving away the competition from the market, needs to have a check in the form of the FI caps. And finally, members of the tribunal, with respect to the cumulative effect, that is creeping violation, I do agree with the honorable claimants in the case where the El Paso versus Argentina envisages the creeping violation of the FET. But members of the tribunal, if I rely on an analogy, the search for the entire forest starts with the search of the tree. So long as we don't have trees in the forest, there won't be a forest, members of the tribunal. We have clearly established that Article 15 of the International Law Commission report, Law Commission on International Obligations, clearly states that cumulative effects do qualify when they do qualify in their individual capacity as well, wherein they breach more or less. Members of the tribunal, there was a concern raised with respect to the nature of the clause in the treaty. Itself is a shopping list clause and henceforth requires a breach of the clauses itself. With this, members of the tribunal, observing that I only have 5 minutes left, may I please move on to about 3 minutes left. May I please move on to the compensation issue and target one principal argument that has been presented by the claimants in the instant case. Members of the tribunal, the one principal argument that has been provided here is that under Article 9.7, that is the most favored nation clause, the claimants should be accorded with fair market value. Members of the tribunal, I would very quickly request the attention of the tribunal at page number 76, which would be 77 of the reader, Madam Arbitrator. In the instant case, if I may read the second clause of Article 9.7, it clearly states that the substantive obligations in other international investment treaties and other trade agreements do not in themselves constitute treatment. Moreover, members of the tribunal, I would draw your attention to Article 9.21, which is at page number 82, read 83 in the PDF reader, members of the tribunal. Article 9.21, that is final award. Members of the tribunal, this is a very important argument. Why? Because in Article 9.21, we can clearly see that the monetary damages are to be awarded at market value, except otherwise provided in Article 9.12. Members of the tribunal, there is no treaty, no case in the entire world that makes a reference which is consciously depicting the intention of the treaty drafters to distinguish market value from the fair market value. The closest case that comes to this, and let me challenge my own submission, is Davos versus India. In Davos versus India, members of the tribunal under Article 6 of the treaty, they use market value, to which the tribunal interpreted it differently using the academic exercise. In this situation, members of the tribunal, the Article 9.21 makes two statements very clear, that for the damages of international obligation breach, market value becomes the proper standard. And if in case there is any other compensation standard, that compensation standard can only be applied when there is an expropriation case. Now, there was a concern raised by the Honorable Tribunal with respect to the valuation date, members of the Tribunal. We completely agree with the reasoning of the Honorable Tribunal that in the case of market value, as has been held by the World Bank draft on the treatment of the investments, as well as the International Valuation Standard Council, that with respect to the valuation date should be on the date of the sale purchase agreement. That was the arm's length agreement entered between the claimants as well as the respondents for the sale of the shares in Kelly Airways. And on that date, whatever was the value of the investment should be taken as a compensation standard. In subsequence to which we also submit, members of the tribunal, that the various tribunals like CMS versus Argentina has also taken into account the detrimental economic situation that the respondents are in right now, which should be taken into consideration by this honorable tribunal while mitigating the damages that have been asked for. And finally, as we have previously demonstrated on various instances, if I may please draw the attention of the honorable tribunal very quickly to a particular fact in the instant case, members of the tribunal. It has been held in page number 33, reader 34, members of the tribunal, paragraph number 29. We can clear. Are the honorable tribunal with me? I see I just have 30 seconds, members of the tribunal. Can I please finish my sentence, if that is okay, Madam President?
Of course.
Thank you so much, Madam President. Madam President, in paragraph number 29, we can clearly see that MECAR cautioned the new, which is at line number 1095. MECAR Air Services cautioned the new VEMA appointed management against taking extravagant approach, given the volatility of the demand in the region. Again, members of the tribunal, in paragraph number 31, we see, citing these losses, representatives of MECAR cautioned that Kelly expansion should be controlled to avoid the exorbitant costs. And again, in the next page, members of the tribunal, at paragraph number 35, in line number 1140, we clearly see that MECAR Air Services preferred injecting these profits into the outstanding debt and improving the financial health in the instant case. None of these requests, none of these advices were paid heed of. And hence, members of the tribunal, we make our submission finally that taking all of this into consideration, there is no breach of Article 9.9, there is no payable compensation, and even if there is to be, it should be market value, taking into consideration the mitigating factors and the economic situation. Thank you so much, members of the tribunal.
Thank you, Counsel. Any rebuttal?
Yes, members of the tribunal, I have two major concerns regarding the submissions by the respondent. First is that respondent submits that New York Convention grants discretion to the domestic courts in recognizing and enforcing an award, and we are not contesting this discretion. However, normatively speaking, it cannot be in the public policy interests of any country to recognize and enforce an award passed on the premises of bribery and corruption allegations. And for this, I rely on the decision of Chevron versus Ecuador 2, which cited Alvin Freeman's work, and I quote, "Fraud and corruption either during the proceedings or in connection with the rendering of judgment may produce a denial of justice." And my second concern is regarding the respondent's contention that compensation falls under substantive obligation, substantive provision under paragraph 2 of the MFN clause. However, we submit that compensation is not a substantive obligation, and this is apparent from the commentary, paragraph 6 of the commentary to Article 36 of the ILC Articles on State Responsibility, which stated that compensation and restitution are it is something which arises, is a secondary obligation arising from a substantive obligation.
Thank you, Counsel. And any rebuttal from the respondents' team?
Indeed, Madam Arbitrator, the claimants unfortunately have once again misunderstood the Chevron case. In that case, the allegations of corruption and fraud were proved. In the instant case, they have not been. Even the seat of the arbitration has taken into account that the allegations of bribery and corruption are not reliable for the jurisprudence. With respect to the other submissions of the MFN clause, members of the tribunal, they have again misinterpreted Article 36 of the ILC draft, wherein it actually says that the secondary and the secondary and sub-secondary obligations of the states cannot be compared unless and until it is dispute specific. In the instant case, there is no dispute specific reference. These are regulatory measures between the two BITs, ours being a free trade agreement, theirs being a BIT, and we have made a lex specialis effort to include market value. That has not been answered by the claimants in the instant case. Members of the tribunal, with this we submit our submissions. Thank you so much.
Thank you, Counsel. I think this concludes today's competition. And I thank my co-arbitrators of presiding and adjudicating this session with me together. And also I particularly thank the counsel teams, the claimants team, the respondents team for addressing the issues and assisting the tribunal in relation to understanding the disputes and presenting the facts and the authorities. And also I thank the Moot Secretariat, the organizers who have made this session running smoothly. Thank you very much. I think that concludes this session. Thank you.
Thank you, Cecilia. I think a round of applause is deserved by all three arbitrators and all four counsel. I'll give you a chance for that, and all of the people watching on the live stream. And with that, I will stop the live stream and we can relax a tiny bit.